Ruling for the defense on that one for all of the reasons stated in Mr. Weinstein's response and opposition.
Now, some of you may have heard about this motion that was filed by the state over the weekend. I guess you could say, well, it wasn't really over the weekend, but it was over the time that they were out of court. And shout out to Thugger Daily for sharing this. I'll link to this in the description. And it's a very funny motion, to say the least. It is from the state. And Miss Love apparently is just having some issues with some of the things that are going on in court. And I wanted to read this to you guys because Judge Whitaker is going to address it at the start of court today. But check this out. The state of Georgia versus Jeffrey Williams. This is a motion in limine to allow the state to present all relevant evidence to the jury and to deny defendant objections to the presentation of the relevant evidence on the basis that said evidence is a waste of time. Basically, she's saying she's mad because the defense is constantly saying that they're wasting her time, and she's sick of them saying, objection, 403, waste of time. So what does she say? She keeps it short, sweet, to the point. The state of Georgia, by and through Fannie T. Willis, District Attorney for Atlanta Judicial Circuit, and the undersigned Chief Deputy District Attorney Adrian Love, got to give her one, hereby moves this honorable court to allow the state to present all relevant evidence to the jury and to deny objections to the presentation of relevant evidence on the basis that said evidence is a waste of time. So she basically just copy and pasted the title of this. And then she says, respectfully submitted on this day, the 8th of October, 2024. All right. And that was by Adrian Love. So most recently, and actually this morning, Doug Weinstein, as y'all know, he's super active on Twitter, especially. He went ahead and responded to that motion. This one is really interesting. If you haven't seen it yet, he just posted that. He just posted it this morning, I believe, and he submitted it to the court late last night. But check this out. DeMonte Kendrick, aka Yak Gotti, represented by Doug Weinstein. What does Doug Weinstein say in response? Opposition to the state's motion to basically allow them to show this evidence, and the said evidence is a waste of time. Doug Weinstein says the defendant DeMonte Kendrick, by and through his undersigned counsel, without waiving any other rights which he is entitled, files this opposition to the state's motion. And what does he say? Stating the following: in a surprisingly succinct and efficient bit of lawyering from the state requests that this honorable court deny all future defense 403 objections regarding the state presenting relevant evidence that is a waste of time. Stop wasting our time. We agree, Doug. The state cites neither statute, case law, nor the highest law in the land, according to the state. Carlson, on evidence to support is its position that the court, take up challenge of overriding the edicts of the Georgia legislature, along with virtually every other legislature and judicial body in our motion, by ignoring OCGA 244403. No, basically saying they have no basis for this motion. Just throw it out, Judge. While the state's motion genuinely merits no response, dang, Doug, the filing of this frivolous motion may indicate the state plans some form of carpet bombing of additional pointless cumulative evidence clearly, excludable under Rule 403, and laying down some type of suppression fire through this motion. Goodness. Therefore, undersigned counsel feels compelled to object. Ironically, the state's motion is a perfect example of the need for this honorable court to weigh in on the state wasting the time of all involved in the present case by barring otherwise relevant evidence that is a waste of time under Rule 403. In a sense, the motion needs no opposition, as the motion itself serves as its own evident opposition. Basically, they're wasting time by filing this motion. They can't even make sure they have all the correct evidence, and they're filing motions against motions, them admitting evidence that's not necessary. I don't know. Wherefore, Mr. Kendrick respectfully requests that this honorable court deny the state's motion to bar ever ruling for the defense in future Rule 403 objections. This, the 8th day of October 2024, and give it up to Doug Weinstein. Excellent response to that. And it's funny, he has a footnote here after he restated what their motion was titled. His footnote says, "Wow, this is really a mouthful." Hey, yo. Yeah, so we're going to see what Judge Whitaker has to say about that with court starting now.
Non-jury days for the next few days. Take the easy ones first. The state's motion in limine about overruling whatever objection the defense might ever offer to evidence on the basis of 403 waste of time and the defense response in opposition thereto. I am ruling for the defense on that one for all of the reasons stated in Mr. Weinstein's response in opposition.
Shout out to Mr. Weinstein. You can tell Judge Whitaker is trying to hold back her laughter. She said, yeah, basically everything Doug Weinstein said in here was right. And we're premiering a new sound effect today.
Right. And so what we have ultimately is that there is no evidence, none.
Shout out to Keith Adams for that sound effect. And that's a win for Judge Whitaker. Great job.
The motion in limine by the state to revisit the court's ruling excluding State's Exhibit 528Y. I have considered that, and I will not be changing my ruling on that. The couple of uncharged post-indictment intrinsic acts that were still outstanding. I've got one question on the circumstance that involved Mr. Ryan and the fight. And I can't remember which co-defendant, but there was a co-defendant who entered a guilty plea and attested to a conversation having been had about protecting a YSL member in the jail and hurting somebody else. What was that about? Do y'all remember that? And did that have anything to do with this? Or were those unrelated?
That was before this.
Okay. All right. Okay. So the court has determined that neither the Ryan situation nor the alleged passing of Percocet to Defendant Williams in court meet the requirements to be an intrinsic act, and so I am not going to admit either of those. And I've also thought again about my ruling out the Stillwell situation of some contraband being in his cell, and I'm going to stand on my ruling with regard to that as well.
What was the ruling? I guess we'll have to go back and look at that. I don't remember Judge Whitaker making a ruling on that one.
One question I saw in my notes, something about the search for Attorney Johnson, the search of Attorney Johnson's laptop, and something that Defendant Williams had requested with regard to that. Can you, Mr. Steele, refresh my memory on what that was about?
Yes, can I have just 1 second?
Sure.
Your Honor.
Yes.
The court. And good morning, Your
Good
Honor.
morning.
Good morning to everyone. Can I make a statement to the court without the prosecutors here and without the media, so it would be on a sealed record? And then if you believe it should
Ooh,
not
we
be
have ex
sealed,
parte meetings.
obviously I will repeat it, or you can have Ms. Winfrey read it back. But I believe that in an abundance of caution.
Come on up.
Okay.
Oh man, we got secret meetings. What could Brian Steele be talking about? Thankfully, we're on delay gang. Shout out to the delay gang. So we get to skip ahead, but I have no idea why he would want to approach. And he said he doesn't want the media to know? Interesting. And good morning to everybody who's stopping by as well. Y'all said Whitaker's voice is... Oh man. Michi said Whitaker's voice is becoming as annoying as Love. Sheesh. No, we gotta be nice to Judge Whitaker. We need her to grant a mistrial already. A proper ex parte? Yeah, this one's okay.
All right, so I appreciate that, Mr. Steele, and that can be sealed to the extent this record ever
Dang, I think we'll never
goes
know.
anywhere.
What could it be about? So shout out to Thugger Daily. So Thugger Daily gives some background on what that ruling was about that Judge Whitaker made. So Thugger Daily says Whitaker also ruled that Lil Rod getting into a fight in jail, which resulted in the stabbing, cannot be used in the trial. Whitaker also denied Love's motion to reconsider the social media post that got her yelled at without hearing any argument from the state. Okay, wow. Yeah, so that was the one that we saw last week where Judge Whitaker had to stop everything because Love came to the bench and they had a back and forth about whether they were going to allow the comments in where it showed the phone number, and they said just exclude the comments and exclude the phone number. Miss Love actually ended up showing the comments and the phone number, and she got in trouble for that. So yeah, she's not going to allow that in either.
All right, I know that there are some things outstanding that concern Mr. Ryan, and there's been a request that that be handled tomorrow instead of today.
Yes, Your Honor.
That's fine. So I'll set that aside for now. I appreciate everybody submitting case law on the issue of whether the RICO conspiracy can be established based on an overt act that's not alleged in the indictment. Frankly, it's a lot of stuff to read, and since some of the submissions were late last night, or, you know, basically all throughout the day yesterday, I have not read all of that, so we'll take that up at some other time, and that's really more of an end of trial issue for us anyway. Okay, I think we're ready to argue and consider the motion in limine, what was it, 62, I guess?
Yes, Your Honor.
All right.
All right, here we go. Good morning, everyone.
Your Honor, may I approach?
Yes.
Your Honor, I just handed this honorable court and the parties, although I ran out of copies, I just gave it to Mr. Matthews. The case I cited in motion limiting number 62, Ebersole, E-B-E-R-S-O-L-E versus State. It's 371 Georgia Appeal, 520. It's in Division 1C as in Colette. It's 901 Southeast 2D, 572, a 2024 case. And Your Honor, what happened in our case previously, and I understand this honorable court was not with us, but the prosecution through ATF agent Racy was testifying. He was at one time with Cobb County Police Department, and he was the lead detective on a case against Mr. Jimmy Winfrey, and that is in Cobb County case number 15-9-2765. And he was asked by Prosecutor Hilton about a jail call. And the jail call had something to the effect of, when Mr. Winfrey comes home, he will be given a Porsche and $250,000. It was something to that effect. And Ms. Hilton then asked Detective Racy, within approximately a month from that time, that jail call that the jurors just heard, did in fact Mr. Winfrey enter a guilty plea? I objected. That guilty plea was vacated and found to be coerced by the Georgia Supreme Court in Winfrey, W-I-N-F-R-E-Y versus State, 304 Georgia, 94, 816 Southeast 2D 613, 2018. And it says specifically in that case that that guilty plea is void, is null, and cannot be used for any purpose. We approached the predecessor judge, and he said he didn't know about that case. It's all on the record. It was at the bench. And I said, well, here's the site. And he said, well, I'm not going to read it. And I said, well, I'm going to cross him on it, and I'm going to subpoena the lawyers, and I put them on my witness list who entered that plea, and I have a certified copy of the Supreme Court opinion vacating it, and this predecessor judge said I couldn't do any of that. Ms. Hilton then came back to the podium and asked Agent Racy the next series of questions. Well, was that plea, for whatever reason, vacated, and a short time later did Mr. Winfrey enter a guilty plea? I again objected. I was not allowed to go into it. The essence of this motion, number 62 of Mr. Williams, is I believe that that's already a constitutional violation, so it has to be harmless beyond a reasonable doubt. Because... Was there any kind of instruction? No. Given? Okay. No, it was, I can't cross on it, Mr. Matthews can't cross on it, we were all barred, and it came out that way that Mr. Winfrey pled guilty. And this dealt with the April 26, 2015 tour bus shooting of a gentleman named Dwayne Carter. He's a phenomenal artist, musical artist, known as Lil Wayne. So
greatest rapper alive,
the state gets that in. Now, the predecessor judge did keep out the indictment on my objection, because the indictment names as co-conspirators, unindicted co-conspirators, Mr. Williams in that event, and it was a RICO count. The further objection was that Mr. Winfrey, he didn't really plead guilty. This is the most favorable Alford plea, and I attached it to Mr. Williams' number 62 that, that I have seen where the predecessor judge specifically, excuse me, not the predecessor judge, Judge Staley, it's S-T-A-L-E-Y, and it's Staley Clark, C-L-A-R-K, Cobb County Superior Court. She specifically acknowledges that this is not a guilty plea, this is a best interest plea. He's not entering admission of guilt. The Honorable Steve Sadow, which is Steve, S-T-E-V-E, and Sadow is S-A-D-O-W, was the lawyer. He specifically said that we are doing this just because it's been 5 years and Mr. Winfrey wants to get out of custody. And I attached that, and I have a certified copy of that Alford plea. Anyway, the way it came in was so wrong, and we had cases that we were citing to the predecessor judge explaining that a person who's not testifying, the fact that they pled guilty, people plead guilty for any numerous reasons, should not be allowed to come in against Mr. Williams and the others here. So, going forward, I put this on this court, honorable court's radar, because it is my belief and understanding, and if it's not going to happen, that's great, that Mr. Kendrick has pled guilty to being in a criminal street gang, specifically YSL, when he was with Mr. Martinez-Arnold. Martinez-Arnold is going to be a witness, but he did not plead guilty to that charge. And it's my understanding that the state intends to have an exhibit, a certified copy of the guilty plea of Mr. Kendrick. And that should not come in against Mr. Williams or any of the other people here for the same reason.
Let me stop and ask the state. Is your position that it comes in against anybody other than Mr. Kendrick?
I love looking like a big Chiquita. Y'all leave that lady alone. She likes yellow, okay? Dang.
I don't believe that a certified copy of Kendrick's conviction would be admissible against another defendant besides Kendrick. And additionally, we intentionally did not tender the certified for Jimmy Winfrey.
For Mr. Winfrey?
Correct. The court did not preclude us. We did not tender it.
Right. Okay, so is it the state's position that not the certified copy of the conviction, but the fact of Mr. Kendrick pleading guilty to, it was gang activity and the gang being YSL, what's the state's position on that with regard to that information coming in on anybody else?
If I can find this plea deal.
His guilty plea, the fact of his guilty plea is admissible against him, and I don't believe that it's admissible in normal cases against anyone else. In this circumstance, I also don't believe that it is. At this time, I don't believe the cases that I've read suggest that it would not be admissible against another defendant. That's
all right. I think that's generally correct.
Just buffering
so, I think I've mentioned before needing a limiting instruction, and I know we're not quite at that stage yet, but I don't know when you intend to introduce that. And
not for the next 2 weeks, I believe.
Okay. Well, can you go ahead and be trying to put together whatever appropriate limiting instruction there would be? And then I would think that the position of both the defense and the state would be the same with regard to Mr. Ryan's murder jury verdict.
Right. Well, I know that the court, I know we addressed it last week, and I was saying that I was looking into that.
Come on, man.
So I don't have anything to counter the position that it's only admissible against Ryan. I don't have any.
Right. And so what we have ultimately is that there is no evidence, none.
All right. So we'd need a similar limiting instruction for that. Let me ask the defendants with regard to whatever information did come in on Mr. Winfrey having pled, that having been overturned somehow, and then him having pled again. There was no information in front of the jury that it was an Alford or a best interest plea?
That's true.
Okay. We've obviously introduced that concept to this jury at this point. Does the defense want me to instruct sometime at the end of the case that, hey, with regard to what you heard about Mr. Winfrey's plea, that was also a best interest plea, and so the same things apply?
Yes, and I intend to
Okay.
call the, in my case in chief, I updated my witness list, the
Okay.
lawyer at the first one when it was coerced by the court, and that's why it wasn't knowingly, freely, and voluntarily given, and then call Mr. Sadow.
All right, well, I don't know that we're going to be doing all of that.